annual Aboriginal Law Speaker Series presented by the Aboriginal Law Students Association. Thank you all for joining us today. It's nice to see such a full house. My name is Teresa O'Crane, and I'm a first-year law student. I'm also a member of the Pasqua Cree Nation. And I'm also a member of ALSA, the first-year representative. So each year, this event, we invite 5 speakers to discuss current topics in Aboriginal law. This year's topic is Aboriginals and the criminal justice system. This presentation will be about 50 minutes with about 5 to 10 minutes at the end for questioning. Before we get started, I'd like to thank all the speakers for taking time out of the busy schedule and to share their knowledge with us. We'd also like to thank the Faculty of Law for providing the space for us, and the APCO Group and the Alberta Law Foundation for their generous financial support. Our speaker today is Robert Yazzie. Robert Yazzie is Chief Justice Emeritus of the Navajo Nation, having served in that capacity from 1992 through 2003. He practiced law in the Navajo Nation for 16 years and was a district judge for 8 years. For 12 years, he was Chief Justice of Navajo Nation Supreme Court. Mr. Yazzie has a BA from Oberlin College of Ohio and a JD from the University of New Mexico School of Law. Currently, he is the director of the Dene Policy Institute of Dene College, Navajo Nation, developing policy using authentic Navajo thinking. He is a member of the Navajo Nation Bar Association. His literary contributions include articles and book chapters on subjects such as Navajo peacemaking, traditional Indian law, and international human rights. He is a visiting professor at the University of New Mexico School of Law, an adjunct professor at the Department of Criminal Justice of Northern Arizona University, and a visiting member of the Faculty of the Education in Formal Participation in Faculties. And yes, I had to practice. Chief Justice Yazzie continues a career devoted to education, informal participation in faculties, lectures, and discussions of traditional Indigenous law at various venues throughout the world. He has a global audience, and he has frequently visited foreign lands to share his wisdom about traditional Indigenous justice and governance. Please help me in welcoming Justice Robert Yazzie.
Yazzie. Yazzie.
Yazzie.
There was a humor that I want to share with you. I've told it over and over again, so every time I tell it, people laugh, and it still works. There was when I was the Chief Justice, I had the pleasure of working with a court solicitor who his wife lived about 3 hours away at the big city, Alberta, New Mexico, and then Friday night was a special time for him. That was the time he would go home and then see his wife after a long week, and would kiss his wife, hug, and say, "Yat eh." And then along about 8 o'clock, she would say to him, his wife would say to him, "Hit the hay." And then next day, somewhere along the line, she gets mad at him. She'll say, "What the hay?" You like that, huh? That's good. Hope we enjoy ourselves, and that what I have to share with you would be meaningful and with some direction. I want to thank the R.J. Simpson, president of the Aboriginal Bar Association here at the
Law Students Association.
Law Student Association. Okay, kind of elevated you. But that's okay. The person who introduced me, and you're very generous and good, show me good hospitality. So we've been talking about Aboriginal and the criminal justice all week. So my question here is, whose criminal justice system are we talking about? Whose criminal justice system should we be talking about? And whose criminal justice system should we be talking? Should we be whose notions of criminality and the rectification of wrong should we be using. And our trip will take us to the past, the present, and the future. And so the question here is, what do we mean when we say the criminal justice system in relation to the Aboriginal and Indigenous peoples? So in America, we have pluralism. What that means is, unlike Canada, who lives under the umbrella of one law for all. The United States wants to be there, but there are Indians all over who want their own independency, with the ability to operate, make their own laws, and be governed by them. So in terms of respect, I mean, for Indian law, Navajo jurisprudence is just about that much. It needs to be wider. There needs to be much more respect and reverence for our law, traditional law. But look back in history, and it's amazing how in August 16, 1555, following Spanish entry into the area we know as Americas and efforts to solidify dominance here, Holy Roman Emperor Charles V, sitting as king, issued a decree and ordered and commanded that the good laws and customs of Indians, including their usages and customs, be kept and executed, be respected. So, do we see much of that today? So when we look at the English colonization, brought with it a means of social control by appointing cooperative indigenous leaders in a system as we know as native or court villages. English colonization of North America differed because Canada adopted a unitary model of one law for all and subjected Indians, Inuit, Métis, and non-native legal system, and the independent United States allowed Indians with limited jurisdiction. So where are we today? I've been sitting here every day, coming here right at 12 o'clock to listen to speakers, and I've heard clearly that the condition here has to improve as far as the criminal justice system goes, especially with respect to the more genuine justice to the First Nations people. But as the picture looks, there's overcrowded jails and prisons, and a prevailing sense of injustice in Indigenous Canada. So the picture in the United States, as far as statistics that is available by the U.S. Justice Department, showing rampant crime in Indian country and massive victimization of Native American in sexual assaults and domestic violence, and the fact that the United States, I've been to many United Nations Declaration on the Rights of Indigenous People, the working group, and the United States always, through the Second Department of State, says that we're doing fine in America. We take care of our Indian people, and so when we hear that, you know, nation states like to appear good to other nation states. So as much as what the United States is saying is that at the present time, it is my hope that my judicial system, and I mean the courts of the Navajo Nation, can be a model for change. That's why I'm here to talk about just that. And that to do so will bring much challenge. but challenge is what we lack. The Indian mind has always dealt with challenge from the beginning of creation. So I will tell you where we are now and discuss what are the possibilities. In the United States, Indian tribes have a process called the tribal courts, and they are a model after state and federal courts. So that system was imposed on the Indian nations, including Navajo Nation, in 1892. And along with that imposition, the government said, we're going to establish a federal Indian courts of Indian offenses. Was designed to get rid of our way of life, our way of thinking, our culture, our language. Just to achieve that purpose, that Court of Indian Offenses was established. So the Navajo Nation superintendent had saw fit to appoint judges, Navajo judges. We don't have an elected system in the Navajo judges. We have 25,000 square miles. We're bigger than some of the states down below, lower 48. And our population is something like 300,000 plus and growing. And we have at least 22 judges, mostly women on the bench for Navajo Nation courts. We have something like 11 judicial districts. So we have people coming and going all the time. So back in, as far as back in the 20s, in the 30s, the Navajo agency superintendent appointed Navajo judges, which was deemed to be a sufficient way to control how well the Court of Indian Offenses will work. And the expectation was very clear. All you Navajos, remember, you must understand that you can't practice your ways anymore. You can't have pluralistic marriage. You can't have your customs and traditional. That's out of the question. So periodically, what the BIA did was to check on proceedings. So an agency representative, a white person usually, a white man usually, would sit in and observe how far along are the Navajos in terms of using the American law over their tradition. So, the report was very good. Like you could get an A. And they said, well, the Navajos are really, catching on. They're really doing well, We don't have a problem with them. And guess what? The Navajo judges who presided those proceedings conducted the proceedings in Navajo language. Kodo ado da juno banda iko hashita hot iniki e kon ni hat kon. You understand that? That's exactly what the Navajo. So in talking, the only thing that came out really clear was the justice method practice, the method of restorative justice. The judges didn't see fit to send anybody to jail or to punish anyone with a heavy fine. There was a grandmother who was brought in, and the agency representative was sitting up there, and the grandmother was sitting here. Instead of imposing sentence on her for stealing horses, that was the charge, they managed to, amend the relationship, and she agreed to return the horse. And she was saying that in a conventional way, my horse just all of a sudden mingling with your horse. That's what happened. So So the but the control was there by the BIA. An example, the Navajo Nation Council back in the late 40s wanted to change the appointment system to election, and the agency superintendent said, "No way, this is my baby. We don't touch it. We run it the way we want to." But lo and behold, in the 1950s, like 1959, is the time when states were asking the Congress, can we take over jurisdiction of Indian country, including Navajo? And Arizona was really gung-ho. And the Navajo Nation Council says, no way. If you want us to be under the states, guess what we can do? We'll adopt a Navajo Nation court model after the state and federal system. So the federal government saw fit that that was a good move, and they stepped back and didn't bother to do anything in terms of assertion of jurisdiction. But there were states where the Congress gave states jurisdiction. Now, as far as being operating your tribal court, like state court, what some of the early traditional leaders did, like the first Chief Justice of the Navajo Nation in back in early 1950, Murray Lincoln, said that we got to develop some procedures. We got to ask the law schools and the lawyers to help us develop those procedures, and they did. And so those were put in place, and away the court system went. So if I can, here I usually draw a line and say, this is a beginning, and this is an ending. Here you have a dispute. Here you have a complaint. Here you have a trial, perhaps a jury trial. So that's the kind of system that Merwin Lincoln says we should adopt. And so it happened. But then in 1980, one of the well-known leaders, Peter MacDonald, says, you know, since we adopted the white man's law, it's not working. We got too many cases going to court, and there's no reconciliation going on from the decisions of judges. We gotta, he said, I'll tell you what, judges, we need to find out how justice was administered 100 years ago, 50 years ago. Let's explore that possibility. And gave him his instruction. Right at that time, there were some very outstanding judges who were very versed in the tradition, and some of the Navajos who became judges had already the experience of practicing law. We have a Navajo Nation Bar Association that has 500 members. And so what the plan was, what the judges said, if we're going to do that, we're going to change this process in the long run. And we're going to go with this circle piece as a paradigm. It represents the law of the universe, the law of the earth, from which we have certain laws that were put in place at the creation stage. That's the natural law, traditional law, custom law, and common law. So when lawyers take Navajo exams, Navajo bar exams, they have to know that stuff. And they have to insert those when there's a legal question pending before the Navajo courts or the Navajo Nation Supreme Court. The question is always, it's good that you bring the state of the law of the federal and state courts. What is the Navajo, what does the Navajo tradition have to say about it, on this question? So I see that there was growth. There was a lot of interest in terms of establishing a quality justice system. So in 1992, I got appointed to the Navajo as the Navajo Nation Chief Justice of the Navajo Nation Supreme Court, and my predecessor, Thomas So, had he had a very good legal mind. He didn't go to law school, but some of the judicial opinion that he produced was just so amazing in some of the most complex cases. So he's the one that said, you know, something that's alternative to this is peacemaking. It's about a circle. It's about community justice, that circle. But what we used 100 years ago, way back from the creation time. So just about that time, I remember that Janet Reno was the Attorney General for the United States. And the U.S. Justice Department said that we have a plan. We have a plan as to how to deal with alcoholism, sexual abuse, violence. We'll establish a drug court. So I had a chance to sit down with Attorney General Reno. I said, well, I support your agenda, but we know our problems. We best know our problems. So if you want to introduce that drug court program into the Navajo courts, then we should be allowed to use our own customs to model that drug court after our traditional values. And that is what we did. But something that was always a challenge in doing that, you never have enough money. Money wasn't always there. If it was available, the U.S. Justice Department in Washington would say, yes, I'll give you this money. But also, here's the instruction, the restriction. This is my agenda. So, but sometimes we say, well, can we do without that? Can we make do with very little and see how far we get? So, even in 2000, in the year 2000, the Navajo Nation Council, the judges had to respond to overcrowded jails. We have bad jail conditions. When people committed crime, we had to let them go because of their civil. Otherwise, we'll be infringing on their civil rights big time. So this is where we began to talk about community justice. Here's where the thought came in. Why don't we just get rid of jails? And why don't we just, start working the system and see what we can devise? And so we looked at the sentencing provision, and we were able to modify it. For example, if there was a wrong done, and if somebody was hurt, and they would say, "Di kishin la," you hurt me. How are you going to remedy so I can have respect for myself? You damage my dignity. So we say that there's a concept of nange, means to put back, to try to restore the victim, the condition of the victim. And so those were the thoughts. So still, the situation today has not changed. The police officer would say we still have high crime rate and elevated levels of violence against women. The Navajo prosecution system has collapsed, and the police are too few in numbers to patrol vast area, 25,000 square miles. I'm sorry. So given that situation, we see that in Canada, the one law for all model is not working. So in terms of thinking how to deal with the world, with our situation in Navajo country, we have to resort to our thinking, because Indian thinking is within this, embodied in the circle. The thinking, the plan, the way to put your plan and thinking together will give you some way to say, these are the steps to bring a remedy. So you can see some resilience. For better or for worse, you see something. So that was the thought. So, to begin that process, we said, how do we do that? We designed peacemaking, which means we let the community resolve their own problem. But we haven't done much in terms of giving their credibility. And the lawyers don't like peacemaking. So, and then the thought here was, why not change the way institute or incorporate traditional adjudication concepts that are embodied in the Navajo Nation Code of Judicial Conduct. And we said, we want to change this code and put Navajo thoughts in it. Put the circle into this judicial code. And best to start with people on top, top down. And look at the code that gives you more of the horizontal picture. And then at the same time, let's examine the traditional way of healing, something that will be alternative to the Western procedure and sentencing option. And lastly, to consider approaches to community, wellness, and other problem-solving courts of adjudication. So when we got together and looked at the judicial code, we formed a committee, and I was a part of the committee. And we studied the question, and a traditional-based Navajo Code of Judicial Ethics was adopted shortly after I became Chief Justice. Our code is substantially the model code, with one big difference. While some provisions were tweaked to meet traditional Navajo expectation or modified for our situation, Canon 1 is very, very unique and very important. And it simply says, Navajo Nation judge shall promote Navajo justice principles. And the opening paragraph states, the Navajo judge should always decide and rule between 4 sacred mountains. So the circle there, which shows 4 sacred mountains, with that gives, if you see the picture, the physical picture of our Navajo Nation, and that's big enough to cover the whole 25,000 square miles. So, and then this particular paragraph meant that judges as Navajos should apply Navajo concepts and procedures of justice, including the maintaining of harmony, which we call wisdom, establishing order, respecting freedom, and talk things out and to promote free discussion of problems. So we laid out the 8 considerations. Before we had the American model that emphasized greatly the relationship between client and the lawyer. But in the model, the Navajo model, we said harmony is understood as injustice in the sense of evil and wrongdoing is a result of disharmony. One of the goals of justice then is for the judge to return the people and their community to harmony in the resolution of dispute. This system doesn't do that. it leaves no room for such consideration. The judges must promote harmony between litigants, achieve harmony through assuring reasonable restitution to victims, and foster harmony by providing the means of offenders or wrongdoers to return to their communities. That is achieved through free discussion, conciliation, consensus, and guide from the judge. And order, the concept of order the Navajo way, is very, very important. And this concept of order comes from our natural law. And when people have observed the law that comes from nature, the law that comes from the earth and the universe, how they relate to each other. And the story goes that there was once chaos, but when order came, it became permanent. So from that, Navajos have a notion of order, to say that Navajo justice is concerned with order, which is related to the principle of harmony. So which means our court procedures and decisions should be keyed to an orderly fashion of dispute. Judicial attitudes is another canon, very important. You know, when you go to court, you feel very nervous, right? You always ask the question, who's sitting? I said, oh no, not that judge. I want that judge, you know? But this canon on judicial attitudes, that a judge should behave to everyone as though if he or she is your relative. You know, that's a must. If you can't live up to that as a judge, then you shouldn't be one. This value requires judges, that's what we call on. Means in a good way, in a more solid way, you provide that leadership to treat everyone equally and fairly, which means that the Navajos believe in equality, horizontal. Instead of me sitting on a high bench and they're looking over somebody like I'm the king, we should just, you know, sit across from each other, take my robe off, and just sit there like another relative, even though I'm the Chief Justice. So the Navajo believe in equality and horizontal person-to-person relationships as a part of their concept of justice. Obligation to a relative extend to everyone, because that is a means of not only addressing personal equality, but creating what we call something that's solid. That if you can get the community to have this sense of solidarity, you know, then you have a sense of justice in all aspects of the community. Another canon deals with coercion, forcing people to do something that they don't want to do. The more you force them, the more they are encouraged to do the wrong. So Navajos knew that. Why do they know that? Because Navajos say nothing is perfect. Because from the time of creation, there was good and there was evil. So we don't look at that, you know, those components the same way as a Christian might. But the way Navajos look at it says there is the concept of justice in those two opposites. And the more you dwell on the negative, the more you criticize, that's all you're going to get. But the more you deal with the good side, and design your procedures accordingly, that's what you'll get. It was a thought for created a judicial code. So along with this, it said that the judges have the duty of making decisions for others. That should not be done with, that should be done with patience, courtesy, without aggression. I mean, my experience as a trial judge, I've seen a lot of lawyers fight. And sometimes, at one point, they even challenge each other physically. So I had to step down from the bench to separate them. And so here that canon on coercion says a judge should patiently listen to proper and relevant evidence. I don't know if we all do that as judges. Sometimes the judge may say, we may have made up their mind already. Hearing the step of going through the process. I know what judges do because I've been one, and I have a strong sense of how the proper way to listen to parties and the improper way of not listening to parties. So, and this includes listening to a reasonable and well-presented arguments of parties or their counsel. Humility. This humility is a traditional concept. When you see a Navajo, a leader, and it's quite different today. You see a person with power, a person who can be approached. We have, like I said, we have 3,000 plus Navajos. We have 24 council delegates, and they're never available to the community. And people are always complaining and say the council delegates are too impersonal. And but to put emphasis on humility, it says Navajo judges are successors of traditional Aboriginals and Navajo peace chiefs. So while the judges are doing this, other government officials are not doing the same thing. They should be doing the same thing. Our council delegate, our president of the Navajo Nation. I'm not just criticizing them for the sake of it. I'm saying that this is a basis for critique of how we should, look at development of Navajo or Indigenous leadership in the future. So when you look at humility, you can say judges are only slightly higher than others, and respect for the decision depends on their personal integrity. Humility is a personal value which prompts people to respect judges for their decisions, not for their position. A fair play procedures of Navajo justice is talking out the problems for a consensus resolution. The judge should encourage free discussion of the problem before the court. I think the more you do find opportunities to say we got to modify our courtrooms and make room where the parties can actually talk to each other. As it is, parties never talk with each other. So the problems never change. So a judge should not encourage, again, permit aggressive behavior, badgering of witnesses, rudeness, infliction of intentional humiliation or embarrassment, or any other conduct that obstructs the rights of a full and fair hearing. So the last one talks about the leadership and governance. And here is that judges may listen to the case, declare the winner, declare the loser, and inflict punishment. So if we rethink that kind of conclusion, then this canon says we got to encourage in the problem-solving process discussion to achieve harmony and to look at the underlying problems. What caused the problem in the first place? Why are you in court? What is the cause? So if we are to have the judges are allowing a free discussion to get to the underlying causes of the problem, people are very happy with that process. And the last one is restitution. What do you do as a remedy? What does the tradition have to offer? So there are concepts that are in existence that when you introduce a concept like a nan-ye, means that this person has been hurt. And in the adversarial process, that means money. But in the Navajo way, it means, you know, how are you going to fix that person, the hurt feelings, you know? And how do you measure how much should be paid, you know? Some say enough so that the hurt feelings will go away. Some say that. And so looking at these 8 considerations, the focus is on individual dignity and fair procedures overseen by those who are steeped in traditional notions of justice. Healing is something that we need to focus on. That the approach that deals with traditional healing. Here we can look at the Western medicine is largely concerned with using medications or mending techniques to deal with illness or injury. And here we can say there are other forms that deal with the mind and spirit. And there is a wide variety of treatments that become both popular and accepted. Establishment medicine and government have somewhat opened the door to traditional alternatives. And there is now room for indigenous medicine and healing. And the focus here is healing in the sense of helping individuals deal with the spiritual side of their injury by crime and some other insult that deal with the people Our view of the elements of healing that were used for an approach to Navajo jurisprudence identifies certain number of elements of healing, and which are used in the Navajo peacemaking. So we can look at that process by saying healing this discourse and procedure promotes respect for self and others, so that a good sense of self-identity and worth that arises from the engendered respect. Attaining a sense of time and place in one's past and one's history is important. So helping people place themselves within a given culture and connecting with its rich history to accept it and to be accepted by it is an aspect of healing. There's always ways to prompt introspection and examination of self to prompt honesty and even confession, so that there may be admissions of responsibility and commitment to dealing with repair, and injury. The 4 elements that we see, something that works in this circle process. And traditional people are well aware of that process when they take on the responsibility to become owners of the problem. And usually you can see some of these elements in that process. Number 1 is like identifying an illness and how dysfunctions behaves allows one to gain control of it. People who have a sense that they have identified a problem and its causes can validate who they are, and they can take control of their own problem and work with others to resolve it. And there is a group discussion by way of getting to the nature of a given problem, identifying who and how the injury affects people, If you can talk out the nature of the hurt, then solutions should present themselves. Group discussion, also an integrated system of discourse decision making. One of the identifying features of illness is a sense of being alone. One healing technique is giving people who are hurt a sense of relationship, so they will know they have a support group or relatives. Offending is individuals acting as though they have no relatives. We should always think and act as though others are your relatives. That is consistent with the natural law. How everything we say, everything we see and feel is related. There is a form of shame in identifying the impacts of one's behavior, and a surrounding family can help identify both the nature of the wrong and the way to deal with it. And the other one is what I said, solidarity. Being with others and being supported by them is a transformative and healing event. It helps people deal with their hurt within their broader context of relationships and relatedness. So now, the other matter that we must look at is the relationship between the court system and the community in Indian country. And here we see that restoring the community is one aspect of restorative justice. It is appropriate to identify the need to take a new look at our communities and involve them in the justice planning. The more there is opportunities for people to participate, the better. One time, when I became a judge, I went to law school, fresh out of law school, and I became a judge. And I wanted so bad to conduct an arraignment, but several weeks later, I got tired of it. I didn't want to do any more arraignment, and I tried to avoid conducting arraignment in every way. But one thing that I must share here is that when I was presiding over a case, there's an old man, elderly man who was sitting over there, raised his hand. Chiche, Yazzie. He says, grandson, I want to speak. So what do? You know, I thought I understood my ethics well, my role. I said, sit down. If you do one more, I'm going to hold you in contempt of court. I clearly remember that. So I said, well, you know, this is inconsistent with what we're trying to do when we're trying to concentrate on developing that restorative justice method that recognizes tradition. So community members are both the service community and the source of leadership for the community-based method of adjudication, based on traditional ethics and healing principles. Bridging the gap between communities and courts. The actors in the local courts are not necessarily of community. A court must be a community institution and not a distant and frightening body. So some people say the more you are a stranger to the process, the more fairness it is to the process of the people, the litigants. Peacemaking says that doesn't matter. If I have my uncle or my aunt sitting over here, they're the best people to preside over the process. There's no conflict of interest. The only thing is that the relatives come together. We only want to get to the bottom of the problem. So another issue is knitting together a fractured criminal justice system. The criminal justice system is still the overbearing one based on principles of trail, nail, and jail, bad people, and it is not based upon consensual and healing approach. And providing the courts with traditional restorative process is important. This means that providing the restorative method that is more in accord with our traditions. And last year we were invited by the U.S. Justice Department of some of the Indian judges across the country. And they wanted to know how can we've been using the U.S. method of justice, but the deviant behavior, the violence is still on the rise. Now we're seriously looking at your community, your experts. How do you share with us? What method have you used all along that worked? So these are the things that we talked about. That the fundamental due process and human rights principles are particularly important. And note that the Navajo ethics principles are largely about self-identity. It's about respectful relationship. And some of the older people used to say, you can't, if you go to law school, you can understand the principles, know how to do an analysis. But if you are a traditional indigenous leader, the best way to know what are the ethics, what are the principles, what will make you a strong leader, standing with your own principles. You have a strong sense of self is what is needed. Self-identity is very important in being a leader. 5 minutes? As a judge, I never used to worry about time. Okay, to the conclusion. As traditional Navajo thinking evolved, I began to see the traditional indigenous justice is based on talking out problems and planning, and that such is the core notions of healing. Respectful interaction with people otherwise classified as victims or as perpetrators yields new perspectives. I do not see our state or federal courts in the United States working because they are not staffed by indigenous actors. They do not respond to rural or indigenous communities in a meaningful way. They are not community institutions. Sometimes you just wish they were, that there was opportunities, something would change. So we looked at the Declaration of the Rights of the Indigenous Peoples, and it tells us of the right of the indigenous communities to organize in accordance with tradition and customary expectation, and the duty to accommodate effective participation of communities, and the requirements to provide effective remedies for those whose rights are infringed or denied. And I share the traditional justice thinking embodied in our Navajo Nation Judicial Ethics Code, because we as Navajo Justice put a lot of effort into it by way of thinking of our identities as judges and the processes that flow from it. The main principle of indigenous healing are there when you consider them in your attempts to think out criminal justice. The time for complaining. When I went to conferences, gatherings, there was always complaints about are past. And time for complaining about what we don't have is over. It is time for us to develop a meaningful criminal justice planning for the future. We must think about children, our grandchildren. You are of many communities and backgrounds, and your talents reflect who you are as members of them. I look to you to get the knowledge and skill for problem solving at home. You may serve in the distant national or provincial capitals, or you may do your lawyering at home. Wherever you serve, you can become more aware of the values and principles I share with you in the context of your own tradition, your own custom. Whose criminal justice solutions are we talking about? Well, given that the recognition decree, Holy Roman Emperor Charles V promulgated on August 6, 1555, recognized the good laws and customs of Indians, are ordered that they be kept and executed. And given that recognition, it is a firm principle of international law reflected in the Declaration of the Rights of the Indigenous Peoples. That would be our Indigenous laws and systems, wouldn't it? So, my conclusion here is return home with good feelings, with good health, and give my best regard to all your relatives that you have.
If you have to leave because it's 1 o'clock for class or anything, feel free to go, but we would like to have some time for question and answers. So we'll take a few extra minutes over time if anybody has any questions.
Do you think that these principles, because Canada's, our justice system, it's nationwide, do you think that these kind of principles can be incorporated into a national justice system like ours, or do you think it has to be something regional and something culturally specific, like the Navajo Nation? Do you think there's any hope for us?
I think the best approach based upon our experience is that, in the United States, if you presented your perspective on the Indigenous laws, people could care less. Lawyers, non-Indigenous lawyers will not listen to you. But I think because of that, to me it doesn't matter. It doesn't matter if the outside world doesn't care about who we are. What matters is that if we recognize ourselves for what we are and be able to say that this is who we are, and be able to look back into our past and be able to say these were the core values that were established, and those are the core values that are still very important. And we can do a lot with it. Like I was saying, the circle. We can see it and say, I don't understand it. Well, that's where we start. And we begin to dialogue with each other. I think there's a lot of potential, especially when young people go to law school and return back to their communities. And what I'm concerned about that is there are a lot of Navajos who finish law school and they come home and they work and practice just like non-Indians. And I wish that there was some means, some ways to talk about these matters, in the process of the law school education. And I think young people are very, very, very open, as opposed to my age level. We're very closed, closed-minded, we're comfortable, living in a certain way. But I think the potential is there, and which is the reason why I teach law to mainly to the young Native students back home. And I think because they're open, when it's time for them to take on leadership, things may be different. They'll be looking for ways to do things in a better way.
Wanted to say thank you for coming. I used to work in the criminal justice system in corrections and dealt with many Aboriginal offenders for several years, most of them registered sex offenders. And their histories are varied from residential school abuses and from even in community abuses, stuff like that. And so we have a problem where I come home from Northwest Territories. In a lot of the Dene communities up there, we have a proportionally higher registered offender population than anywhere else in the country. And the current, it's like how does your community deal with those type of offenders? And when it comes to like sentencing, but also in community healing, because we're struggling. And some of these things are. Last client I dealt with, it was later found to be innocent, but his lawyer from legal aid told him, plead guilty, they'll go easier on him. We're struggling with these things, and it's, Corrections Canada has a Find Your Inner Warrior program for Aboriginal offenders. I hate that program because they're trying to do like their national law system, create a national pan-Aboriginal healing program in the correctional system, run by non-Aboriginal people in consultation with an Aboriginal elder who the last one just recently quit because they weren't listening to you. Like within a Navajo perspective, like how do you deal with such type of offenders?
Well, one of the things that I think that's very that works well when you're dealing with that situation is when you sit down with a person who has trauma, who has experienced dysfunction or thing, if you allow them to talk about those things and work with them. And I think it's just a matter for children, to that these matters be discussed among ourselves. I mean, that may mean going to therapy, to visit your childhood at your age, or to go to a medicine people and be able to help yourself in that way. Some of these are very hard cases, especially when some have experienced sexual molestation. Very, very difficult. Sometimes, people don't want to be helped. They live in denial. So somehow, some way, I mean, we have to pay attention to that. I think that there's opportunities now to deal with those matters.
The other problem is on the victim side, trying to do this kind of reconciliation with victims. Like, having done this for almost 12 years, I've heard a lot of victims say that they want to see that person thrown in jail and never be released or things like that. They don't care about their past history or things like that. And so, and that's the other area where we're trying to, we have some people who are banned from the communities currently.
One of the clear obvious things is that when people are given their family support, if the families show up when you're sick, when you're in jail, then it means a lot. That's why we say relationship is an important component of the justice system, and the concept of justice just means that you work with what works, and I think here we have a relationship that will if the families are there to work with you, to give you the support that you need, to give you the encouragement, that means a lot. And I think a lot of our young Navajos go without that. And it's a very lonely, road if you're walking, from day to day by yourself, no one to talk with, no one to seek advice from. And I think back in the traditional days, talking these out, talk to your kids as mother and father is what I heard from again and again and again. And I think we just need to revisit our values. I mean, if there's nothing there, we can say there is something there. Traditional law, traditional values never die.
Yeah, when I heard you were speaking today, it reminded me of excuse me, a book I read called Dancing with a Ghost. Exploring Indian Realities by Rupert Ross. He quoted you as saying, in the Navajo peacemaking process, the most important piece of paper is the Kleenex. That's what he said.
Right.
And he had a lot of good examples from his practice as a lawyer. Well, I was just wondering, in your community, people who are quite traditional and they say know about different traditions of Navajo people, whether it's just stories of like from fallen boy, from fallen girl, like these ideas of different parts of a person. Does that help in moving forward in healing? To know that there's more than one side, because our justice system deals with punishing an offender, right? And it deals with terror, scaring them from doing it again, which is very different from an approach where
nature, yeah, and the respect that we're talking about is very, very important. Especially when you say that there's connection here, there's relationship here. So when you tell stories of such type, there are songs that go with it, there are prayers that go with it. So if you say that you have these traumas, these problems, and you want to restore yourself in a good way, the medicine people will say, well, I have the means to help you out. And one of those is cut the deep, meaning that there's a corn pollen that will help you find your way, or it provides for an access to your future. And so those prayers do work, and those songs that people do, they really work. And when the past, when people met chaos, when it meant life or death, people rely on their prayers. There's a lot of values taught in the songs. There's a lot of direction that's given in the prayers, and they do work. Yes, that's why we do sweat lodges, right? That's why we do family gathering, to assure that we're a family, and it really does a lot of good to the family and to the community.
We're just gonna have to wrap it up now.
All right, thank you all for coming. And a couple of gifts here for